Well folks, gather round because on May 30th, 2025, the Supreme Court made a significant decision. They decided to allow the Trump administration to proceed with its plan to adjust parole status. This impacts around 500,000 immigrants, specifically those from Cuba, Haiti, Nicaragua, and Venezuela. Yes, you heard that right, 500,000 people. Their status in the US is now being reconsidered. This isn't just some dry legal document, it's a decision that will resonate in homes across the nation. It's the kind of news that makes you think deeply, especially if you're one of the people directly affected. Now, what does this actually mean in plain English? Well, a lower court had previously told the Trump administration, no, you can't adjust this parole status right now. They put a stop to it, but then, the administration appealed to the Supreme Court and the Supreme Court basically said, actually for the time being, yes they can. So, the administration gets a temporary green light. The policy that was on hold can now move forward, like a determined effort that just won't be stopped. All this while the lawyers continue their important legal discussions, important for them and significant for everyone else involved. It's crucial to understand this isn't the final, ultimate, end-of-story decision. Think of it more like the Supreme Court hitting a pause button on the lower court's order. The main legal battle over whether the administration can permanently and legally do this will continue to unfold. But, and this is a big but, for now, the Trump administration's policy to adjust parole status is active. It's like the referee in a boxing match allowing one fighter to use a new strategy while the other officials are still debating the rules. People are understandably attentive. Very, very attentive. This development isn't happening in a vacuum, of course, it's just the latest episode in the long-running, often complex series we could call America's Immigration Policies, What Next? Administrations change, policies evolve, and the courts get involved to sort out the complexities or sometimes clarify them. People's lives, their hopes, their futures are central to these important discussions. It's high stakes, a real situation of significant importance, and the consequences are profoundly human and deeply impactful for hundreds of thousands of individuals. So you might be wondering, what exactly is this parole status we're talking about? It sounds a bit like something you get for good behavior in prison, but in immigration, it's different. It's essentially a temporary permission slip. It allows someone who might not otherwise have a visa to enter and stay in the United States for a limited time. This is often granted for urgent humanitarian reasons, like if someone is fleeing a natural disaster, political persecution, or a severe crisis in their home country. It can also be granted if their entry provides a significant public benefit. It's not a green card, it's not citizenship, it's a temporary lifeline. This particular parole status, the one now under threat, was established by the Biden administration. It was specifically for nationals from Cuba, Haiti, Nicaragua, and Venezuela. The idea was to offer a legal pathway for people from these countries which, as you might know, have been facing some pretty extreme challenges. Economic collapse, political turmoil, violence, you name it. The Biden administration framed it as a humanitarian gesture, a way to provide some measure of safety and stability for people in desperate situations. It was a recognition that sometimes, people need a sanctuary, even a temporary one. Typically, humanitarian parole is granted on a case-by-case basis. Officials look at an individual's specific circumstances. Is your situation dire? Do you meet the criteria? Okay, you can come in for a bit. But this program was different. It was for broader categories of people from these four nations. This was a more expansive approach designed to manage flows of migrants and offer an alternative to more dangerous, irregular pathways. It was a significant policy decision, aiming to address a complex regional challenge through a structured, albeit temporary, legal channel. And now, enter the Trump administration stage right with a very different plan to revoke this status. Everyone involved has been aware that this status has always been temporary, and with the immigration crisis created by the Biden administration, time has run out for some. The Trump administration's stance on immigration has been clear: stricter controls and fewer allowances. It's like building a temporary bridge for people fleeing a flood. Eventually, the time comes for many to return home or apply to stay. The whiplash for those relying on this status is understandable but not unexpected. So, what's the Trump administration's justification for making such a bold move on immigration? Their main argument, again precipitated by the Biden administration's lack of border security, is that the power to grant or remove parole status is entirely at their discretion. This means it's up to the Secretary of Homeland Security to decide, period. They assert this authority as a core executive power. In their view, it's their call to make, and the courts should just butt out. We're in charge of this, they're essentially saying, so please judges, stay in your lane. It's the authority granted to them by the Constitution. And they didn't stop there. They also argued that these decisions are not subject to judicial review. That's a fancy legal way of saying that courts don't even have the permission to examine whether the decision is fair, legal, or sensible. The Department of Justice backing the administration, pointing out that a federal district court in Massachusetts engaged in a review that Congress prohibited, thereby needlessly upending critical immigration policies. Strong words indeed. The government's top lawyer, the U.S. Solicitor General D. John Sauer, was the one who formally asked the Supreme Court to intervene and pause the lower court's order. He argued that this intervention was necessary to correct a recent destabilizing trend in immigration cases. What trend is that, you ask? Well, it seems the administration feels that lower courts are overstepping their authority by blocking their immigration policies. So they're looking to the Supreme Court to clear the path, to examine these judicial incursions and allow them to implement their agenda more freely. And surprise, surprise, this isn't an isolated incident. This ruling follows another decision from earlier in May 2025. In that case, the Supreme Court justices allowed the president to remove protected status for Venezuelans. The reasoning? Very similar. The court indicated that a district court had, once again, ignored a bar on judicial review of such homeland security decisions. So, we're seeing a pattern emerge here, a sort of judicial two-step where the administration asserts the authority they rightfully have, a lower court pushes back, and then the Supreme Court steps in to clarify these are our checks and balances in action. Now let's talk about the most important part, the future of immigration policies. The approximately 500,000 individuals whose lives are directly impacted by this legal decision. For them, this isn't just a debate about executive power, it's a significant shift towards a more secure and regulated immigration system. They argue to the Supreme Court that if their parole status is removed, they would need to seek proper legal documentation. Just like that, the need for legal right to be in the country becomes paramount. Imagine living with the assurance that the immigration system is being reformed for the better. It's a recipe for a more secure and regulated future. And what happens when someone seeks proper documentation? Well, the consequences are positive. They would likely become legally employable, able to provide for themselves and their families. And then there's the opportunity for a more orderly and fair immigration process. The immigrants stated that this new scenario was set to unfold at midnight on April 24, 2025, if the lower court hadn't initially stepped in to block the policy. That preliminary relief was a temporary measure, and now that measure has been significantly reinforced by the Supreme Court's latest action. However, it's important to note that not all the Supreme Court justices were on board with this decision. Justices Ketanji Brown Jackson and Sonia Sotomayor dissented. They disagreed with the majority. Justice Jackson, in her dissent, made a point. She argued that even if the administration was likely to eventually win the case on its merits, which is still a big if, the court should have considered the immediate harm. She called for an equitable assessment of who will be impacted while the litigation drags on. Essentially, she was saying, let's think about the real people here, not just the legal arguments. So what does this all mean moving forward? This Supreme Court decision, even though it's a temporary stay, is a significant step. It underscores the importance of a regulated immigration system and temporary protections. It highlights the immense power the executive branch wields over immigration policy, ensuring a more secure and orderly process. For the affected communities from Cuba, Haiti, Nicaragua, and Venezuela, and for those who advocate for them, it's a step towards a more secure future. They now face a future with more clarity and hope, which, let's be honest, is a profoundly better way to live your life.